Hi there, this is Christy McKinley with Litigation Survival School, and I'm here today to give you a procedural overview of a typical case. The first thing that you need to know about court is where is the courthouse? Depending on which court you're in and which county you're in, that can be very different. Most people watching this video will be in Superior Court, but it's also possible that you'll be in District Court, and those are county specific. If you're in Pierce County Superior Court, you're going to find the courthouse at 930 Tacoma Avenue. If you're in King County Superior Court, there's one in Seattle and there's one in Kent. The district courts are peppered throughout Pierce County and King County. No matter what court your case is in, you're going to want to know where it is. Look it up on Google, find the address, make sure that you go down and visit the court. If you know what courtroom you're in, it can be really useful to also visit the courtroom that you're going to be in and get familiar with that. The next thing that you want to know is who are the actors at the courthouse. The first person that you're going to interact with at the courthouse, most likely, is the clerk. The clerk is the person that you give all of your papers to for them to file or to put into your case in the court. When you meet the clerk, it is very important that you be nice. A lot of people make the mistake of thinking that the clerk is not a very important person in the courthouse, and nothing could be further from the truth. The clerk is who you file your paperwork with. They're also the person who takes or processes the papers so that they get to the judge. They control the flow of paperwork, control the flow of information. They can answer questions about where to go and where to find things, and they're much more likely to be helpful if you are nice to them. The worst thing that you can do is come in and be rude to pretty much anyone in the courthouse, but definitely the clerk. Another person that you're going to encounter at the courthouse, but not probably until the very end of your case, is the judge. The judge is the ultimate decision maker, which means that at the very end of your case, when it's coming to a close, they're going to make a decision about what your permanent orders look like, or what things are going to be once your case is closed, how you guys are going to conduct yourselves from then until the future. They don't make decisions typically about what happens prior to the end. There's another sort of judicial officer that you'll encounter called a commissioner that is often confused with judges, but they make decisions about what to do while the case is pending. So for example, if you have a divorce, you are ultimately going to get a divorce order, maybe a parenting plan, child support order from a judge, and that order will stay in place until your children are 18 years old, or until everything is accomplished with your divorce. But they won't issue you a temporary parenting plan or anything, any sort of decision, until the very end. So sometimes you need something more immediate. So for instance, when you file and your divorce is going to be pending for a year and a half, a commissioner is who's going to give you all of the orders about what to do between when you file and when you get to the very end. Another really important person is the judicial assistant or bailiff. Different courts call them by different names, but they basically assist the judge. Again, you want to be very nice to these people because they control the information that gets to the judge. When you want to send an email or communicate with the judge, you're actually going to email the judicial assistant or bailiff, and then they will carry the message to the judge. They also control the judge's schedule. So when you need help, and you will need help, you're going to want to have been nice to them and accommodating. The last person that we're going to talk about is an invaluable resource. You won't encounter them unless you seek them out, but you should, and that is the law librarian. Like libraries or librarians in standalone libraries, or the King County Library, the Pierce County Library, they are invaluable. These people are saints. They are sort of a hub of information about where resources are, where you can find the answers to your questions. They will not answer your questions directly, but they will point you in the direction that you need to go. Using the law librarian can be a massive help in your case. So now that you know who you're going to find at the courthouse, getting to the meat of it, how do you start your case? You start a case by filing a document called a petition. This is your ticket into court, and it says what your case is about and what decisions you want the judge to make at the end. This document does not say how you want things to go between filing and the end. It just dictates what decisions you want the judge to make at the very end of your case. When you file this petition and you get the case started, you also file what's called a summons. A summons is what you give to the other party to let them know that they're being summoned into court. This is their ticket into court and how you let them know that they need to come participate in the case. You're going to file these with the person that we talked about at the very beginning, the clerk. Once you've done that, you're going to want to serve the papers, which means give the papers to the other party, the person that you're summoning. There's a concept of notice that makes this proceeding fair, or as fair as possible. This concept dictates that as a general rule, the other party has a right to have a copy of everything that you give to the court. And in order for the court to know that they were given that, and that to know that this process has been fair, you have to prove to the court that you gave everything to them. In order to do that, you have to have someone who's not you, who's 18 or over, give them the paperwork, and then fill out what's called an affidavit of service. It's just a statement saying, I gave the other party these papers. I'm not the person who's involved in this litigation, and here are the papers that I gave them, and what day and what time. Once you've given the petition and the summons and served it on the other person, your case may take a year, it may take a year and a half, but there's only 3 ways out of a case, or actually to end a case. There are 4 ways out. One way is to dismiss the case, to decide you don't want to do it after all, but there's only 3 ways to end a case. One of those is agreement, where you and the other party come together and say, look, we've come up with something, we agree to something, and we don't need the court to decide, we're just going to enter these orders so that it's official, but this is our agreement. The other way that is less common is if the other party refuses to participate. So they get all the paperwork they're supposed to, but they decide they're just not going to respond and they're just not going to come to court. And that's what's called a default. The court will just give the person who did come what they want and be done with it. The third way is to go to trial. And that is where you go at the very end, present all of your evidence, the other person presents all of their evidence, and then the judge makes a decision. In the meantime, during that time that we talked about, the year or year and a half between when you start the case and when the case ends, if you need something, so for instance, a temporary parenting plan or an order that says you can't sell the house until we make a decision about what we're going to do with the house, then you file what's called a motion. A motion is a little bit like a mini petition. You file something saying, here's what I want, here are the issues, here's why you should give me what I want, and then you go and you ask the court to make a decision that's going to last until you get to trial. When you write a motion, there's a format that is taught in law school that is very helpful. It's called IRAC, which is IRAC. It stands for Issue, Rule, Analysis, Conclusion, which means that you start your motion with, here's the issue that I want the court to decide. Here's the question that is before the court. And then if I know the rule, then I put the rule in. Here's the rule that dictates what the court should decide. And then analysis means here's all the facts. Here's how the rule relates to my case. So if I have a house that I don't want to be sold, this is all the reasons that this rule means that you shouldn't sell it. And then a conclusion. At the end, you just say, here's what I want the court to order. When you file your motion, you're also going to file what's called a notice of hearing. Or note for motion. In different jurisdictions, it's called different things, but typically either it's a note for motion or a notice of hearing. Just like the motion is like a mini petition, this is like a mini summons. This is how you tell the other person that they need to show up to talk about the motion, and it gives them the day, the time, and the location. Just like the petition and summons, these have to be served by somebody who's 18 or over, not you, and is willing to write a statement about what they served and when they served it. Once all that is done, you will have a date. You will have a hearing date when you have to go to the court and talk to the court about all the requests that you made. When you do that, you want to make sure that you are dressed appropriately. So that means wear your nice clothes. This is what some people refer to as their Sunday best. You need to cover your shoulders, your midriff, and your knees. Ideally, you will be wearing closed-toed shoes. That's not a strict rule, but that's the decorum for court. When you come for your hearing, you should show up 15 minutes prior to the start of your court date. This is going to let you do two things. It's going to let you find the courtroom that you're supposed to be in, and it's also going to let you check in with the judicial assistant or bailiff. That same person that we talked about, that is the assistant to the judge. When you come to court, they want to know who showed up for court and which cases everybody is there for. So you will, before the hearing, go up to where there's a person sitting in front of the judge's seat and say, I am this person. I'm either the petitioner or the respondent, the moving party or the responding party. The way that you decide which one of those you are is if you filed the petition, you're the petitioner. If you're responding to the petition, you're the respondent. By the same token, if you filed the motion, you're the moving party. And if you're responding to the motion, you're the responding party. If you can't keep these straight, it's not a big deal. The judicial assistant will help you, but those are your roles. When you get there and you've checked in, you'll have a seat in what look like pews. Those are the seats that everybody sits in until their case is called or until it's their turn to go up. The court will call your case, which means it will say it's petitioner versus respondent. Then they'll say your case number, and then they'll say what kind of motion you're there for. Once they do that, the judge will either say, could you please introduce yourself? Or sometimes they'll just look at you, expecting you to know that you need to introduce yourself. When you introduce yourself, you say your name. You say whether you're the moving party or the responding party. You can also say, I filed the motion, or I'm responding to the motion if you can't remember those terms. And then you say, and then you pause and let the other person do the same thing. If you filed the motion, once everyone's introduced themselves, then it will be your turn to talk about the motion. You'll start with what motion did you file? So we are here for my motion for a temporary parenting plan. And then you'll say, what do you want the court to do? I want the court to adopt my parenting plan. And then you're going to tell the court all the reasons that it should. Oftentimes those are already in your motion, but if you have anything to add, you can, and you can just reiterate your arguments or your reasons from the motion. Once you do that, the other person gets to talk, and if you are the responding party, you do something very similar. You say, what do you want to happen? What do you want the court to do? And why should the court do it? Once that person has spoken, the moving party or the first party who spoke gets a chance to rebut or talk back to the things that the responding party just said, and then everybody stops talking. At that point, the judge will give a decision, an answer. When the judge gives their answer or their decision, you should be writing down what the court says. Because sometimes the judge will just write an order for you, and sometimes they'll give their entire decision, and then they will ask you to draft an order. You want to have been writing the entire time so that you know what to put in the order if they ask you to draft one. When you are in your hearing, you need to remember that the court can answer only the question raised by the motion. That is to say, if you only asked for a parenting plan in your motion, you can't show up at the hearing and ask for child support as well. You can ask for a parenting plan and child support in the motion and go to a hearing and have both of those issues heard at the same time, but only if you put them both in the motion. If you've asked for a parenting plan and child support but didn't mention anything about having the other party removed from the house, you cannot bring that up at the hearing, and the court cannot order the other person to move because it wasn't in the motion. The court cannot make any decisions except for the ones that you've put in your motion. Keeping that in mind, it's really important to stay on point. So talking about things that aren't going to help the court make that decision is going to waste time. It's going to waste your time because you only have a certain amount of time to talk to the court, and it's going to waste the court time. And sometimes that's going to really frustrate the court. I'm going to pause here to say, I keep saying the court. You're talking to the court, you're asking the court to do something, and that can be confusing because to most people, the court is a place. But when legal practitioners are talking about the court, sometimes that does mean the courthouse, the physical place. Sometimes that means the judge or the commissioner. We are taught that it is all one. It's this sort of fiction that the judge and the commissioner, they're all part of one entity, which is the court. And so oftentimes you'll hear people talk about the court made a decision, and that means the judge or the commissioner. So that's a general overview of the life of a case, both how you get to the very end and get a decision at the end, and how you get things done in between. Please come back and watch the rest of our videos for more information about how to navigate the court system.